Have you ever considered what happens when your data, perhaps your online purchases or personal messages, travels across borders to different countries? It is not just a simple journey. This digital movement involves complex legal considerations. A transfer risk assessment, often abbreviated as TRA, is a crucial process designed to evaluate the risks associated with moving personal data from one jurisdiction to another, particularly when the destination country may not offer an equivalent level of data protection as the origin. Its core purpose is to ensure that personal data remains adequately protected, even when it leaves its initial legal safeguard. The necessity of TRAs stems largely from international data protection laws, such as the General Data Protection Regulation, or GDPR, in Europe. After significant court rulings, like the Schrems II decision, organizations cannot simply relying on standard contractual clauses alone for international transfers. They must actively assess whether the destination country's laws and practices might undermine the effectiveness of those contractual safeguards, posing a risk to individuals' data. This is especially true if a third country's government agencies could access transferred data without sufficient legal oversight. To conduct an effective TRA, organizations should first map their data flows to understand where data is going. Next, they must identify the specific transfer mechanism being used, such as standard contractual clauses or binding corporate rules. Then, a detailed analysis of the data protection laws and practices in the recipient country is performed, looking for potential gaps or conflicts with the standards of the originating jurisdiction. This involves considering the likelihood and severity of risks, including government access to data, lack of effective remedies for data subjects, or weak enforcement of data protection principles. A key component of a robust TRA is documenting the assessment process thoroughly and identifying any supplementary measures needed to mitigate identified risks. These might include enhanced encryption, pseudonymization, or strict contractual obligations for data access and deletion. Understanding the nuances of these measures and their legal standing in different jurisdictions is vital for compliance and demonstrating accountability to regulatory authorities. By systematically evaluating and documenting the risks of international data transfers, organizations can proactively safeguard personal information and comply with stringent global data protection mandates. This rigorous approach not only protects individuals' rights but also reinforces trust and avoids potential legal penalties and reputational damage for businesses operating across borders.